Court calls case People versus Destin Hopkins.
People. Assistant Public Defender Natalie Pate on behalf of Mr. Hopkins, who is present via Zoom. Sir, can you please state your name for the record?
Destin Hopkins.
We open with a standard procedural call, People versus Destin Hopkins. Defense immediately requests an adjournment due to a pending matter in circuit court. This is legally significant. When a defendant has overlapping cases in multiple courts, defense counsel must coordinate strategy carefully. A resolution in circuit court could affect plea posture, sentencing exposure, or probation risk here. Judge Simpson grants the adjournment efficiently, no resistance, no lecture. That signals the request was reasonable and properly framed. Early docket entries often look simple, but they establish tone. Today begins in a calm procedural rhythm. Scheduling, coordination, administrative correction, nothing adversarial yet. But watch how that tone evolves later when compliance becomes an issue rather than scheduling. For now, this is structured docket management, controlled, efficient, routine.
Thank you, Your Honor. Ultimately, I'm respectfully requesting an adjournment. Mr. Hopkins does have a pending VOP in circuit court, which he just texted me a brief update about this morning that I do need to have a longer conversation with him about. I'm asking if the court would consider an adjournment into possibly early June. If not, late May would also work, I believe. I would be able to get the information needed by that time.
May 21st, 2025.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case People versus Jared Roberson.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Roberson, who should also be present via Zoom. Sir, can you please unmute and state your name for the record if you're there?
Jared Roberson.
You should dial in.
Yeah.
All right, what are we doing?
Thank you, Your Honor. Mr. Roberson is trying to get his license valid. He states to me that he is eligible in June. We're asking for an adjournment sometime into June if possible.
Correction.
No, this isn't a license case.
Registration. Sorry.
He's trying to get the registration.
Did I say license? I apologize, Your Honor.
So you want an adjournment too?
Yes.
I'll adjourn the matter to June 4th, 2025, 9 a.m.
Thank you, Your Honor.
All right. Thank you, sir.
Thank you, Your Honor. Thank you, Mr. Robertson.
Thank you.
And thank you for that.
Court calls the case People versus Kevin Stickler.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stichler, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Kevin Stichler.
Offer available to the defendant in this case to plead guilty or contest with count 2 of retail fraud in the 3rd degree, 93-day misdemeanor, $500 fine or trouble amount, contrary to PAC code 750-356D as in dog 4, with the dismissal of count 1 retail fraud in the 2nd degree, the 1-year misdemeanor. And I have discussed that with my client, Your Honor, and he does wish to accept that offer today, pleading no contest to the added count 2.
We now enter a plea proceeding. Kevin Stittler accepting a no contest plea to retail fraud 3rd degree. Key distinction: a no contest plea is not an admission of guilt in the traditional sense. However, for sentencing purposes, the court treats it exactly like a guilty plea. Judge Simpson explains maximum penalties clearly. Up to 93 days in jail, $500 fine, potentially triple the property value if higher. This advisement is mandatory. The defendant must understand exposure before the plea can be accepted. Notice the negotiation outcome. Count 1, a higher degree retail fraud charge, is dismissed. That's leverage exchange. The defendant reduces risk by accepting certainty. This is structured plea bargaining. Predictable, controlled, legally sound.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record.
Kevin Stichler.
All right, you can put your hand down. Sir, it is this court's understanding that you're going to plead no contest to the charge retail fraud in the 3rd degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
I do, Your Honor.
All right. Do you understand what a no contest plea is?
Yes.
2 things about it. I have to make sure you understand it. First of all, means that you're not desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Basis of the no contest plea.
Potential civil liability, Your Honor.
Sir, to the charge of retail fraud third degree, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Correct.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
This section is the constitutional core of the plea. The judge outlines waived rights: right to trial, right to confront witnesses, right to compel witnesses, right to remain silent, presumption of innocence, right to appeal. Each right must be acknowledged. If even one is skipped, the plea can later be challenged. Notice the consistent confirmations. Yes, Your Honor. That establishes voluntariness. The judge also confirms no threats, no off-record promises. That protects the record from coercion claims. This is textbook plea colloquy, deliberate, structured, methodical. Once the court finds a sufficient factual basis, the plea becomes binding.
I do, Your Honor. Yes.
You understand you're giving up your right to appeal upright.
Yes.
Are you on probation or parole?
I am on probation.
Are you on probation at the time of this offense, sir?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily and of your own free will?
I am, Your Honor.
All right. Court has been provided Pittsfield Township Department of Public Safety report for their case 21-13877. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
You are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed.
The plea is accepted. Defendant referred to probation for pre-sentence investigation. The PSI process is not minor. Probation will now evaluate background, criminal history, substance use patterns, employment stability, and risk assessment. That report influences sentencing heavily. Bond continues. That means the court sees no immediate custody risk. This case moves cleanly because compliance and agreement are present. The system functions smoothly when cooperation exists. But we are about to move into a case where compliance breaks and tone changes.
Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be May 14th.
Yes.
May 14th, 2025, 9 a.m. Bond will continue. Sir, I'll have you wait on the line. We're going to put you in with our probation intake so we can get the sentencing process started, okay?
Yes. Thank you very much, Your Honor.
All right, thank you, sir.
Thank you, Your Honor. Thank you, sir.
Thank you, Daniel.
Oh, okay, all right. They're not right there, sir. However, I think they took a brief lunch break. If you do want to stay on the line, otherwise you'll have to call down. But if you do want to stay on the line, the moment they get back, we'll put you in.
Do you want me to? Natalie said she'd text me the number. If that's okay, I can call.
That's fine too, also, sir.
Okay, I will do that. I got to go to work anyway, but I'll call as soon as I can.
All right, thank you.
Thank you, Your Honor. I appreciate it very much.
All right. Court calls the case, People versus Jason Williams.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Williams. Mr. Williams, please state your name for the record.
Jason Williams.
Your Honor, we're here for a pre-trial. There's also a pending bond violation.
There is.
I have spoken about the violation with my client. I believe today he's going to admit to the violation, and he would like to make a statement on his own behalf.
Yes, that being said is, I admit to the violation and, I know I wasn't supposed to have alcohol in my system. No excuse, but the last few weeks, sir, I had so much going on in my life, money issues, the car issues, whatnot, family issues, and no, there's no excuse because
Now we enter a bond violation involving alcohol consumption. This is serious, particularly in an OWI-related matter. When alcohol is a condition of bond, compliance is directly tied to public safety. The defendant admits violation but explains stress, financial strain, family issues. Legally, stress does not excuse violation of a court order. Bond conditions are mandatory, not advisory. Defense emphasizes treatment participation, weekly therapy, AA meetings. That's mitigation strategy. But prosecution escalates, requesting scram tether monitoring, 24-hour alcohol detection. This is the shift from trust-based supervision to enforced compliance. Once trust weakens, supervision tightens.
you said what you said, and I wasn't trying to get in trouble or anything, and I've still been going to my program, and that's still been helping me. So going to my program weekly by weekly and dropping with them and whatnot, and just still trying to grow as an individual and whatnot. So that's all I have to really say right now, sir.
If I may, Your Honor, add to that. So Mr. Williams is attending substance abuse treatment in Detroit. I believe it's called Community Care First.
Yes.
He goes there weekly for group therapy and is also attending AA meetings.
Do I have any documentation regarding any of that?
I believe I have provided to Ms. Londy. I'm happy to give it to the court. He gave me his schedule and
But,
his
yeah, but how
enrollment.
do I know that he's actually going to that?
You said what?
I have his enrollment paperwork. I'm happy to get an updated progress report from that program and get that to the court.
And we sign in every week. So
There every
we
week.
sign in every week. And I think you said that's start also. Talk down.
How long has he been doing that?
I've been doing this going on 3 months. Oh well, it's January 20th, February, March. Almost going on 3 months.
Nothing, well, I was gonna say nothing, but I did want the court to know he is fully employed at U-Haul. He works full-time there. He is hoping to stay out of custody and continue working, continue going to his treatment program and just, get things back under control.
Yes.
I'm sorry, what is that?
Oh,
Ms. Londy.
In anticipation of the court accepting the admission to the bond violation, people would request enough change in bond conditions. First and foremost, there was a prior bond violation in March that the court accepted the admission to allow the defendant to continue testing with where he's testing now. Unfortunately, this is an OWI case, and it does have a prior from 2012, and now this is the second time that we've got an alcohol violation. So I am requesting that he be placed on a scram tether. I do believe that community safety and the public safety risk of having this person not be on 24-hour testing supervision is too great to ignore at this time. So I am requesting the court order that and have him placed on the scram tether.
My problem is that and this is why I don't like to do it this way. I gave you a chance, Mr. Allen. I gave you a chance with the last violation. What?
Sorry, just for me to speak, I wasn't informed that about so I didn't know anything about the last violation. Like this would have all been like this wouldn't happen again. It wouldn't never happen again. Like it wouldn't never happen again. Like I say, I'm still just I'm working on it, sir. I definitely apologize. I'm just hoping like you could please work with me just one more chance, and you won't hear about it.
Here's the thing. I don't mind giving people chances, but I gave you an opportunity to test in Novi with results to community correction. I did that back think it looks like on March 5th. And I get these negative tests. Well, first of all, there were like numerous miss samples.
No, oh, sorry.
I'm going by their report.
Okay.
Then I get negative results. Then on March 27th, I get, well, that's when the ETG comes through. I get a positive alcohol result. Here's part of my problem. I don't know how much you're drinking. And so that comes through, you know you've been drinking. And then on the 2nd, we get a negative result from your ETG. But then by the 9th, you're drinking again.
And the second. And that's like,
What?
I'm just up here thinking, sir, like second, like knife should have came back negative also.
It came back negative.
Yeah, negative on the second.
On the 2nd, it's negative because
Right,
it's only going to pick it up for whatever period in time. But then by the 9th, you're drinking again.
Judge Simpson now analyzes ETG testing patterns. ETG detects alcohol metabolites within a limited time frame. Positive results on March 27th and again on April 9th indicate repeated consumption. The judge's concern expands beyond drinking. It centers on credibility. When he asks whether the defendant told his counselor, he's assessing honesty in treatment participation. Courts expect proactive disclosure in recovery-based supervision. Failure to self-report undermines trust. Bond supervision operates on 2 pillars, compliance and candor. When both weaken, judicial patience narrows. We are approaching consequence.
Or sometime shortly before that or before that, you're drinking again. And I don't have any reason to doubt anything, but I don't know what treatment you're in. I don't have that in front of me, first of all, right now. I understand why I may not. But also, I don't even understand or nor can I trust what you're indicating is your participation with it.
So, like at the meetings, sir, there are 2-hour meetings every week. Like they're NAA, talk to a counselor and whatnot. And like once again.
Did you tell the counselor you're drinking?
You said, well, did I tell the counselor I'm drinking? No, I'm not drinking.
Pardon?
I'm not drinking. What? Like I'm confused right now. You said that.
Pardon?
Did you tell your counselor that you had the positive
Oh,
alcohol test?
no, because
You didn't.
I just got informed. I just got informed on Monday. So I was going to tell him this.
Well, hold it. Whether you got informed or not, you knew you were drinking.
No, I just got informed on Monday that I violated. That's what I'm telling you on Monday.
Okay, listen real close to what I'm saying. Whether you were violated or not, right?
Right.
You knew you were drinking. And so my question is, you knowing that, did you tell your counselor you were drinking?
No, I haven't spoke with her yet. I was going to speak with her on Friday about that and tell her like.
I thought you went every week.
I go every week.
Okay.
Every week.
So today is the 23rd, right?
Right.
No, just listen to me.
Okay.
Today's the 23rd, which means presumably from the time of the results, you had at least 2 of those meetings. And you haven't told your counselor that you were drinking. That's from the last instance.
All right. Last week, sir, we was off due to Easter on Friday. So we
Here's the
didn't.
problem, young man. You're going to have to get your addiction under control. You got an excuse for everything. If you didn't get caught, you would say nothing, either to your treatment, certainly not to the court, it seems to me. And then you would go about continuing to drink. I'll adjourn the matter to May 21st, 2025, 9 a.m.
This is the turning point. Judge Simpson adjourns the matter, but immediately follows with bond revocation. That sequencing matters. The case itself is continued, but the defendant's freedom is not. When the judge says, "I gave you a chance," that is judicial trust being formally withdrawn. Courts often extend flexibility on first violations, especially where treatment is involved. But repeated alcohol violations in an OWI context elevate public safety concerns. Bond revocation is not a punishment for the original charge. It is a response to non-compliance with release conditions. Legally, once bond conditions are violated and admitted, the court has authority to revoke. However, notice nuance. The judge leaves room for reconsideration if documentation of treatment progress is provided. That signals enforcement with conditional opportunity. This is structured accountability, not emotional reaction.
At this point, given his violation, his admission to the violation, defendant's bond is hereby ordered revoked. I will reconsider giving him a bond and maybe releasing him with certain conditions once I see the information or progress report.
I was going to ask, Your Honor, do you think that we could get him assessed by the jail and see if there's any treatment programs that this county can offer him, maybe a higher level of treatment than he's already engaged in?
Well, I don't know what he's engaged in. I mean, I can't, because what he's telling me doesn't make a whole lot of sense.
Well, I'll get that to the court and whatever other information I can obtain.
All right. Thank you. Court calls the case, People versus Del Marcel Bass.
Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Bass. Mr. Bass, can you please state your name for the record?
No, Marcel Bass.
Your Honor, Mr. Bass is going to plead to 257.326. I do not have a signed advice of rights form for him. I can get that signed and submit to the court after the hearing if you would like that. I did review it with him.
Is that the?
Yes, sure. I'm in bad count two of MCL 257.326.
All right. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
Del Marcel Bass.
Sir, it is this court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. Do you understand that?
Yes, sir.
Understanding that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I'm on probation.
All right. Were you on probation at the time of this offense in July of 24?
I believe so. I can't. I want to say yes.
Okay. If you were on that probation at that time, you understand that your plea in this case could be a violation of that probation.
Yes, and I talked to my probation officer.
Okay. All right, but I have to advise you of this, that if the court does consider this a violation of that probation, you could be sentenced to the maximum allowable under that other charge. You understand that, sir?
Yes.
Understanding that, you still wish to plead to this charge?
Yes.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes.
On September 24, 2000, I'm sorry, July 9th, 2024, at the location of Washington near Gulf site in Pittsfield Township, Washington County, state of Michigan, did you have custody or control of a motor vehicle?
Yes, sir.
Did you allow someone who was otherwise ineligible to operate that motor vehicle that may have indeed been yourself?
Yes, sir.
Counsel, have I complied with the court?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea to count 2, count 1 is dismissed. Sir, anything you want to say before I impose sentence?
I apologize for driving. I'm actually trying to work on getting my license back through Secretary of State, which I have to have a hearing and all of that, which means I got to go through all the paperwork before I can get a hearing set.
Got it. Okay. Fines and costs of $250. I'll suspend 90 days in jail. When do you think you can get this paid?
Can I get at least a month?
I guess so. Pay it by May 31st, 2025.
Yes,
Okay.
sir. I appreciate it.
All right. Take care. Don't forget about that.
Oh, I won't.
All right.
Thank you.
Court does call the case of the people versus Jashawn Clifton.
And so on behalf of Dismissal Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Clifton.
Your Honor, we worked out an agreement. Defendant has made restitution in this matter, so I'm moving to dismiss.
No objection.
No objection.
Case is just, is he present? Mr. Clifton?
Yeah, yes, I'm here.
Okay. You have any problem with them dismissing this?
No, sir.
I didn't think you would. Okay. Case is dismissed. You have a great day.
Thank you, Your Honor. You as well.
This dismissal is outcome driven. Defense states restitution has been made. The prosecution moves to dismiss. No objection. Restitution changes leverage. When financial harm is fully remedied and there is no ongoing public safety concern, dismissal becomes viable. Notice how brief this exchange is. Compliance compresses courtroom time. Compare this to the earlier violation hearing that extended over multiple minutes of scrutiny. Behavior determines courtroom friction.
Court calls the case of the people versus Quintez Harris.
So on behalf of Dismissal Township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Harris. Is on Zoom.
Hope springs eternal, but no.
Well, given that I don't have an explanation for the to figure out, ask for an adjournment for the record.
Bench warrant will issue bond 5,000. 10%, that warrant will issue immediately. Court does call the case of the people versus Bruce Hesterly.
And on behalf of Dismissal Township.
Good afternoon, Assistant Public Defender Lauren Penny on behalf of Mr. Hesterly. We have come to a resolution that involves both cases. He's ending in 1582. He has given me permission to admit to double parking on his behalf. And in exchange, the interference case would be dismissed, which is the case ending in 1581.
That is correct, Your Honor. So I move that count to double parking in 1582. If you accept the admission, I will dismiss the original charge as well as case 1581.
That's called the case people versus Maurice Keeley. Key.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Key. Ms. Key, please state your name. I'm requesting an adjournment. This case was just arraigned, I think, last week. I've not received, well, when I checked yesterday, I hadn't received the police report. So I just.
June 4th, 2025, 9 a.m. Where's your invited to case? Thank you, Mr. Key.
Here, defense requests adjournment because discovery was recently received. This protects due process. A defendant must review police reports and digital evidence before making plea decisions. Judge Simpson grants adjournment with a firm date. That balances preparation rights with docket control. Structured scheduling continues.
Court calls case People versus Terrence Leonard.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Natalie Tate on behalf of Mr. Leonard, who gave me permission to accept the offer on his behalf.
Your Honor, I move to add count 2 of double parking, accepted admission, and dismiss the original charge.
Do you admit on behalf of your client to the fact that on February 21st, 2025, at Carpenter Road in Pittsfield Township, Washington County, that they double parked a motor vehicle?
Yes, Your Honor.
Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can they get that paid?
He's asking for 2 months, Your Honor.
May 30th, 2025.
Thank you.
Court calls case People versus Juan Mercado.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Mercado. Mr. Mercado has also given me permission to admit to double parking on his behalf.
Your Honor, I move to add count 2 of double parking, if you accept that admission, to dismiss the original charge.
On behalf of your client, do you admit responsibility to the fact that on July 9th, 2021, location of State Street, Pittsfield Township, Washington County, State of Michigan, that they double parked a motor vehicle?
Yes.
Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can they get that paid?
I think he can pay this week. I asked for next Friday, just in case.
Pay it by May 9th, 2025. Court calls case of the People versus Demarius. Who knows?
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Natalie Tate with and on behalf of Demarius Munoz, who should be present via Zoom.
Yes, hello.
Can you please state
Hello?
your name for the record?
State your name.
Damaris Monreal Muñez.
Thank you. All right.
Thank you, Your Honor. So unfortunately, Mrs. Munoz's brother did call our office downtown this morning, so I do now have good contact information for her. I was not able to have a good or any conversation with her prior to today. I'd request an adjournment.
This is a contact breakdown issue. Defense states they were unable to have meaningful communication with the client prior to today. That alone justifies adjournment. Due process requires attorney-client consultation before substantive proceedings. Without it, effective assistance of counsel is compromised. Judge Simpson adjourns to May 21st. No friction. This is procedural fairness in action. Notice the consistency in this courtroom. When preparation issues are legitimate, time is granted. The system protects readiness as much as it enforces compliance.
All right. Manuel, adjourn your matter out to May 21st, 2025. 9 a.m. or as your invite indicates, okay?
Okay, thank you.
All right, thank you.
Thank you so much. We'll be in touch.
Court does call the case of the People versus Daniel Noggle.
Conrad Siller on behalf of Pittsfield Township.
And good afternoon, Your Honor. Brendan Bolsky appearing on behalf of Daniel Noggle. Mr. Noggle, please state your name for the record, sir.
Daniel Noggle.
You got a camera? Thank you. All right.
Got me now?
State your name
This
for the
is,
record, sir.
Daniel Noggle.
Okay.
Your
All right,
Honor,
this
today's
is
the date.
arraignment and go ahead.
I was going to say today's date and time set for an arraignment and also a pretrial. As to the arraignment, wait formal reading and stand mute.
And in every way, formal reading, standing mute, court will enter a not guilty plea.
Thank you.
All right.
As it relates to the pretrial, Your Honor, Mr. Siller had sent me the discovery, and I received a link yesterday for the digital discovery. I haven't been able to review that yet, so we're just going to ask for an adjournment for me to review the discovery.
The next available date is May 21st.
Okay.
So I'll adjourn the matter to May 21st, 2025, 9 a.m. or as your invite indicates, as to bond.
Now we enter a more serious matter, an OWI with blood draw evidence. Defense emphasizes stability. 45 years old, employed, no criminal history, voluntarily appeared. Prosecution highlights BAC 0.317. That is extremely elevated. High BAC shifts bond analysis toward public safety risk. Judge Simpson sets $15,000 personal recognizance bond. That means no upfront payment unless violated. But strict conditions follow. No assaultive behavior, no weapons, no alcohol, no drugs. This is structured preventive supervision. The court balances presumption of innocence with public risk mitigation.
Your Honor, Mr. Noggle is 45 years old. He resides in Clinton, Michigan. He's gainfully employed at R&R Vehicle Sales. He's been there for over 3 years. He has no prior criminal history. He spent 1 day in jail on this. Right after he got charged, he retained counsel, and he voluntarily appeared for today's court date. I would ask for a personal bond.
It's a blood draw, Your Honor.
Yes.
121.
121.
No crash. Traffic stop for failing to maintain lane integrity. No priors.
All right. Defendant's bond is set at a $15,000 personal recognizance bond. I'll order standard conditions, including no assaultive behavior or any possession of weapons or ammunition. You understand that, sir?
I believe I understand it.
What do you not understand?
Do I have to pay a bond or?
No.
Oh, okay.
I mean, I can make it so you do, but
No, I just don't understand, sir.
all right. Well, no, I'm releasing you on a $15,000 personal recognizance with standard conditions, no assaultive behavior or possession of weapons and ammunition. You understand that, sir?
Yes, sir.
There should be no possession of any alcohol, recreational marijuana, or any illegal drugs.
Okay.
All right.
Yes,
And
sir.
I'll leave it there. I'm not going to put up any testing at this time.
Thank you, Judge.
All right. Thank you. Let's call the case, People versus Jalen Powell.
Senator Siller on behalf of.
Good afternoon, Assistant Public Defender Laura Perry on behalf of Mr. Powell. Mr. Powell, please state your name for the record.
Jalen Poe.
Jalen Powder's case involves a suspended license. Defense confirms license remains suspended. Defendant states employment and intent to pay. Adjournment granted to June 4th. Intent alone is not compliance. Proof of reinstatement must be shown next date. Courts allow opportunity for correction, but that opportunity has a deadline.
There he is. Okay, got it. Okay, what are we doing?
Your Honor, I haven't had contact with Mr. Powell. I would ask him to provide us with an update with his license if he can.
Our last report as of the 17th, he's still suspended.
Well, given that, Your Honor, I asked for an adjournment on Mr. Powell's behalf so he can try to get his license valid.
Are you still working on that, sir?
Yes, I'm currently working. I'm now employed, and I couldn't text her back because my other phone is broke. So I wish I could let her know what's going on, but I can definitely make a payment within this week, Friday.
All right, I'll let you guys figure it out. June 4th, 2025, 9 a.m. On continued. Thank you. Court calls the case People versus India Robinson.
Senator Siller on behalf of the township.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Robinson, who should be present via Zoom.
Yes, ma'am. Good morning.
All right, state your name.
India Robinson.
Thank you.
Thank you, Your Honor. There is a resolution in this matter to which my client will be accepting the offer extended of pleading to added count 2 of allowing an ineligible person to drive, and in exchange, count 1 will be dismissed.
That's correct, Your Honor. So I moved at MCL 257.326. You accept that guilty plea and move to dismiss original charge.
Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record, please.
India Robinson.
All right, ma'am, it is this court's understanding that you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days, $100 fine plus court cost. Do you understand that?
Yes, sir.
Understanding that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
On the date of March 18, 2024, at the location of Laura Road in Pittsfield Township, Washtenaw County, State of Michigan, did you have custody or control of a motor vehicle?
Yes, sir.
Did you allow someone who was otherwise ineligible, inclusive of yourself, to operate that motor vehicle?
Yes, sir.
All right, counsel, have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed.
India Robinson pleads guilty to allowing an ineligible driver. Defense requests community service instead of $250 fine. Judge denies and imposes payment deadline. This reinforces courtroom consistency. Monetary penalties are standard absent extraordinary hardship. 90 days jail suspended. Conditional leverage remains.
Ma'am, anything you want to say before I impose sentence?
No, sir.
Fines and costs of $250. I'll suspend 90 days in jail. When can you get that paid, ma'am?
I actually spoke to my attorney and asked if it was an alternative for us.
Yes, Miss Robinson did ask me, Your Honor, to make a request that if she would be allowed to do community service. I did advise her that typically this court orders the fine, but I'm asking if the court would consider allowing her to do possibly even 40 hours of community service instead of the $250 fine. But we do understand that would be imposed and would ask for 2 to 3 months for her to pay it if that is what the sentence of the court would be.
All right. Court is going to order the $250. I'll order at this time that be paid by May 31st or May 30th, 2025.
Thank you.
90 days in jail is suspended. Thank you.
Thank you.
Court calls the case People versus Kerry Vickerson.
Ed Siller on behalf of the township.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Vickerson. You should be on Zoom, Your Honor.
Yes, I am.
You got it.
Yeah.
All right, what are we doing?
Your Honor, we are asking for an adjournment of this case. Mr. Vickerson has a ticket out in 14B that he was suspended. I did send him that information and he's working on getting that resolved.
Adjourn it June 4th, 2025, 9 a.m.
Another adjournment based on outstanding ticket resolution. Again, compliance pathway offered. Pattern holds. Administrative correction earns time.
Where is your invite indicates? All right, thank you, Mr. Vickers.
Yes, Your Honor. Thank you.
Court does call the cases of the People versus Juwan Wilson.
Ed Siller on behalf of Pittsfield Township.
All four
cases.
Yes, sir.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Wilson. Please state your name.
Wilson.
Here we have a resolution that involves all 4 cases. Do you want to put on the record?
I will, Your Honor. In case 0893.
Okay.
I'm going to plead guilty. It's approved for the test.
Deferred. Okay.
In case 0570. I have count 2 of double parking.
0570.
Parking, if you accept that admission and this original charge. In addition, the 2 remaining cases will also be dismissed, 0569 and 2479.
And that is our understanding of the agreement.
Raise your right hand. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Juwan Wilson.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud under the Pittsfield Township ordinance. Is that correct?
Yes.
Now, that's a misdemeanor punishable by up to 90 days, $500 fine plus court cost. Do you understand that?
Yes.
All right. Understanding that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, sir.
of your own free will?
Yeah.
And because you believe that you're indeed guilty of this offense?
Yes.
On the date of April 19th, 2019, location of 7,000 East Michigan Avenue, that being the Walmart store, what'd you do?
Put items in my cart, walked out without paying.
Okay, you just tried to walk directly out without paying?
I mean, I paid for some of them, but I didn't pay for all of them.
Okay, tell me what you did. You put stuff in your cart.
Yeah.
You went through, was it self-checkout?
Self-checkout, yeah.
And
I didn't pay
what,
for
you
everything.
scanned some items, didn't scan others, and then tried to, so you skip scan?
Yeah, I skipped scan.
And you tried to walk out without paying?
Yep.
Store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to do that, did you?
No.
And these items you didn't pay for and tried to walk out, these were items that were offered for sale by Walmart?
Yes.
Counsel, have I complied with the court rule?
Yes, Your Honor.
Satisfied, Judge.
Court will accept the defendant's plea of guilty to that charge. In that case, and that being 0893. In the other case being 0570, sir. On the date of March 25th, 2019, location of southbound State Street in Pittsfield Township, Washington County, State of Michigan. Do you admit responsibility to double park your motor vehicle?
Yes, sir.
All right, court will accept that admission in that case. Cases ending in 569 and 2478, those are dismissed.
479, Your Honor.
24, what did I say, 8? Okay, 2479.
Thank you.
All right, so on the double parking, fines and costs of $180, when can you get that paid?
I could pay half of it today.
You can pay 90 today?
Yeah.
He's got 100. He doesn't want to give me the other 10. I'm just saying. No, don't say nothing. Just, all right, so you're gonna pay 90 today, then when can you pay the balance?
2 weeks.
2 weeks. Pay it by May, then I'll just indicate balance by May 16th.
Okay.
Okay. On that one, that'll take care of that case. Then on this case, is there restitution issues involved in this? No, but he's deferred, so we're trying to get the deferred on it. So defendant is referred on that case to probation for a pre-sentence investigation and report and consideration of deferred sentencing. Sentence in this matter will be May 14th? May 14th, 2025, 9 a.m. or as you're invited. On continue.
Thank you.
Thank you.
Multiple case resolution, 1 retail fraud plea, 1 double parking admission, 2 dismissals. Structured negotiation produces controlled outcomes. Fine split payment accepted. Partial payment today, balance by May 16th. The system allows staged compliance, but enforces deadlines. This is proportional justice in motion.
Court does call the case as People versus James Raggett.
Conrad Silver on behalf of Pittsfield Township.
On arraignment. Your name, sir?
James Patrick Raggett III.
All right. Mr. Raggett, you are before the court on a misdemeanor complaint that alleges that on or about January 5th, 2025 at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you did operate a motor vehicle with a high blood alcohol content. You understand that charge, sir?
Yes.
That is a misdemeanor. It's punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could order rehabilitative services or any community service the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, sir.
All right, my first question for you, sir, is do you wish to be represented by an attorney? Seriously?
Yes, Your Honor.
So you heard me, you heard through that?
Yes.
You do wish to be represented by an attorney? It's a public defender, please.
Good afternoon, Assistant Public Defender Lauren Kearney, on behalf of Mr. Raggett. Is
Yes.
that correct? We waive any further reading, stand mute to the charges, and ask for another pretrial date, Your Honor.
And then having waived formal reading, further formal reading, standing mute, court will enter not guilty plea on his behalf. I'll adjourn the pretrial in this matter to May 21st, 2025, 9 a.m. or as your invite indicate. As to bond.
Your Honor, the blood alcohol content was very elevated in this case, 0.317.
0.317?
Correct. Had to do with the operation of the vehicle at the movie theater on Carpenter Road, Cinemark.
Got it.
This child was present at the theater, but not in the vehicle.
Your Honor, I'd request a personal bond and standard conditions. Is the court inclined to give him a scram tether, or?
I am inclined.
He says he does have a scram tether. He's on probation out of what?
Black out of Washtenaw County. That's circuit
Who's the
court.
judge?
Perry.
Oh, on 15th District Court.
Yes.
It says he's on probation in front of Judge Perry. For OWI.
That was
in their
destruction of property.
Sobriety court?
No, I'm currently enrolled in accountable choices, as well as the accountable choices program as a result of the original sentence. And I'm currently on a scram tether that was a result of the incident January 5th.
It's not a drunk driving case. It's a MDO.
Yeah, it was related to
building.
Yeah.
So you're on the scram as a result of what?
Violation of probation, because I'm on probation and they were notified of the case.
Of this case?
Yes.
So they put you on a scram tether?
Yes.
Oh, I see.
Did they say how long?
No, I have to go back June 19th.
Still gonna need an order, I think. All right. So I'm gonna set the, was there anything else on that, Mr.?
Nothing else, Your Honor.
I'm gonna set his bond at a $35,000 personal recognizance bond at this time. I'm gonna order standard conditions, including no assault behavior or possession of any weapons or ammunition. You understand that, sir?
Yes, Your Honor.
There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, Your Honor.
If I gave you a drug test, would you pass?
Yes.
You would?
Yes.
All right. I'm gonna have urine test one time random per month in this case. I'm gonna also order a scram tether after 15th District Court tether ceases. So, sir, what I'm indicating is that if you come off of the current scram that you're on, you have to get a new scram.
Yes.
For this case.
I understand.
All right. 21st.
Thank you.
Yeah, thank you. Christopher Akron.
Conrad Silver on behalf of Dismissals Township.
This in a ring.
This is a show cause.
This show cause. For failure to appear.
Yes.
Okay. Your name, sir? Christopher Akron. Sir, you are before the court on a charge that alleges that on or about April 28th, 2024, at the location of Platte Road in Pittsfield Township, Washtenaw County, State of Michigan, that you operated an unregistered motor vehicle.
Yes,
You
sir.
understand that? That's a misdemeanor punishable by up to 90 days and a $500 fine plus court costs. You understand that?
Yes, sir.
All right. First question I have for you, sir, is do you want to be represented by an attorney?
Yes.
Pardon?
Yes, sir.
All right, this is public defender.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Eckler, we would waive any formal reading, stand mute, and ask for an adjourned pretrial date, please.
Defendant having waived formal readings, standing mute, court will enter a not guilty plea on his behalf.
This docket illustrates the spectrum of district court practice. Adjournments granted where preparation required. Plea bargains structured with clear rights advisement. Bond revoked when compliance repeatedly fails. Restitution rewarded with dismissal. Bench warrant issued for non-appearance. High BAC cases met with heightened supervision. Minor offenses resolved proportionally. Judge Simpson's approach is consistent. Flexibility for cooperation, escalation for repeated violation, structured deadlines across all cases. The through line today is accountability. When defendants engage honestly and proactively, proceedings remain efficient. When trust weakens, supervision intensifies. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.